Fighting back against U.S. sanctions, that's how international media is interpreting new trade-related legislation from China. So what are the new rules exactly, and will companies get caught in the crossfire between the two powers? And the outgoing Trump administration risks an explosive departure from the White House in the Taiwan Straits. What are Washington's calculations on the issue, and what can Beijing expect from the incoming Biden administration? Welcome to The Point, coming to you live from Beijing. I'm Li Xin. China's Ministry of Commerce issued new rules on 9th of January to block what it calls the unjustified extraterritorial application of foreign legislation. Chinese companies will now be able to take legal action whenever they find their normal trade-related activities restricted by foreign laws and their legitimate rights hurt. The order says where there exists unjustified extraterritorial application of foreign legislation and other measures, it may decide that the competent Department of Commerce of the State Council of China shall issue a prohibition order to the effect that the relevant foreign legislation and other measures are not accepted, executed, or observed. Now, the new rules have made international headlines, with global media reporting the measures are a pushback from China against U.S. sanctions. Exactly why has China introduced these new rules, and what will be their global impact? Joining me for the discussion are Fang Yi, attorney at the Chinese law firm Gen, and via Skype from Beijing, David Blair, vice president and senior economist at the Center for China and Globalization, a think tank. Welcome to The Point. So, let me go to Wang Yi first. Now, many media outlets are describing the new rules as China hitting back against the U.S. sanctions. Do you agree with that assessment? Why exactly the rules?
Thank you for hosting me on the show. This rule is not a standalone document from the Chinese government. As we know, for context, the international trade laws of China is a body of laws that had been growing over many years. And this document, issued by the Ministry of Commerce, is the Chinese government's statement against unjustified trade sanctions of third parties doing business with Chinese entities and persons. So the purpose of this document is to protect Chinese citizens and entities doing international business with countries that are not issuing sanctions themselves, but are affected by sanctions measures of countries that are not directly related to the transaction.
Mr. Blair, let me go to you. What is your understanding of the message through these new rules? And is there a concrete example you can use to help us understand this new rule?
Well, partly this is the Chinese government's attempt to resist the long arm of U.S. law, where the U.S. is taking rather extraordinary interpretations of the reach of its domestic laws and applying it to international trade and commerce. For example, a company is subject to U.S. law, and the courts in the U.S. have determined this to be the case. If the transaction goes to an American bank, if it uses the U.S. dollar, or if any of the internet traffic goes through a U.S.-based server. So that's a very dangerous situation for executives of the companies involved. In a way, this legislation is, I think, an attempt to protect the executives of Chinese corporations who are doing business internationally. Because what they're required to do is report conflicts to the Chinese government, to the Ministry of Commerce, and then the Ministry of Commerce will act in their behalf, bringing a case to the World Trade Organization or other international organizations, or possibly government-to-government negotiations,
Okay.
rather than making the executives of the company bear the risks.
All right. Fang Yi, I don't know whether you understood what Mr. Blair's interpretation of this new law correctly. There was a bit of a fluctuation of the volume, but basically what Mr. Blair was saying was this law is to, at least among others, to help protect Chinese business executives, so the Chinese government will act in their behalf, on their behalf, to protect their rights and interests. What is your understanding of this new law?
That is my understanding as well. And as we know, China is not the first country to issue legislation or forms of law to counteract against extraterritorial application of laws on trade matters. As Macron had said, that this document was based on partially the experience of the European Union, which had blocking statutes that to similar effect protects member states and citizens of their member states against these measures.
Well,
so,
yeah, as you said, exercising unjustified state power over the territory of another is defined as long-arm jurisdiction, and China has said its measures aim to constrain such behavior as is against international law. According to experts, the United Nations has long encouraged countries to have similar legislation. The EU, as Fang Yi just mentioned, had also similar rules since 1996. Mr. Blair, why do you think it took China so long to enact similar legislation? Why does it feel it needs to do it now?
Well, that's a good question. China has been active in international trade, very active for a long time. I think it's because recently, especially in the Huawei case and in other cases, the long arm of U.S. law has been applied to Chinese persons and Chinese entities. So that's made it urgent for the Chinese government to act in this way. But I think the U.S. is overusing its tool. This is a very powerful tool. Earlier on, 20 or 30 years ago, it was used mostly against drug traffickers or terrorist groups. It's a very different thing to try to apply this kind of power against other sovereign states, especially against large sovereign states. And I think by overusing the tool, the U.S. government is going to push states to find ways to counter it, and will end up losing the ability to use the tool sort of in anti-terrorist and anti-corruption and anti-drug trafficking cases.
Basically, the Chinese government sees this, and a lot of analysts here see the U.S. long-arm jurisdiction being abused to achieve U.S. economic and geopolitical gains, and to keep Chinese companies at check, such as in the Huawei case. And that's why it has become especially urgent for China to enact this law. And yet, the specifics of this law, for instance, a lot of discussion is being had. Let's take a look at, for instance, this one specific article which says, where a person complies with the foreign legislation and other measures within the scope of a prohibition order and thus infringes upon the legitimate rights and interests of a citizen, legal person, or other organization of China, the latter may, in accordance with law, institute legal proceedings in a people's court and claim for compensation by the person, except where the former person is granted exemption in accordance with Article 8 of these rules. So it signifies that a Chinese enterprises can legally, or a person can legally recover financial losses, which was not possible before. Fang, how will this work in practice?
In practice, personally, as an attorney, I do not wish to see that companies are fighting against each other, former business partners fighting against each other because they are being caught between the geopolitical tensions of two nations. This article, providing a basis for compensation for injury in these type of transactions, is the last tool, I hope, used by companies trying to recover some of the losses. But in reality, I think what companies would be more willing to do is to negotiate and consider the effect of these new rules and other compliance matters, both in China and in the other country, so that the risks among the transacting parties are allocated more fairly, and that to avoid losses or litigations.
Mr. Blair, according to these new rules, if a company of a third country hurts the interests of a Chinese company under pressure from U.S. sanctions, the Chinese company can sue the former and claim compensation. What kind of impact will this have, according to you, on China's international trade with third countries?
Well, I think there's going to have to be international agreements to cover this, because we're reaching a situation where executives of companies feel like they're at risk even when they travel internationally, if they go to meetings, if they go on vacation, as we've seen. There's a lot of risk being created by all these conflicting laws among countries, and it would be much better for international trade and commerce and just simple international communication if major countries of the world, especially the EU, China, the U.S., and other major industrialized countries, could get together and agree on rules of the road so that individuals within the countries are not bearing so much risk. This is really should be a government-to-government negotiation rather than having companies bear all the risk.
Yeah, but Mr. Blair, given the situation that we're seeing between China and the United States, and now, of course, China pushing back against U.S. sanctions, and the U.S., I guess, will not be so happy, that their long arm being constrained. Do you think it is possible at all in the near future that there will be some kind of government-to-government dialogue between the United States with its major trading partners, such as China and the European Union?
Well, unfortunately, that's going to be very difficult, I think. Regardless of which administration's in power in the United States. I'm not saying much give on that. This type of extraterritoriality really started under the Obama administration, not under the Trump. It didn't start under the Trump administration. Mm-hmm. So I'm not expecting it to change. I expect to see more decoupling. I expect that we're going to see companies within China some companies try to wall themselves off from this kind of extraterritorial legislation, and others may try to separate themselves from the kind of trade where they could get into trouble. So we'll see a division of those companies, I suspect.
Okay. Well,
and
that's
may be a good thing for China.
Yeah, it may be a good thing. I have about 30 seconds to give to Fang Yi. Any practical advice you can give to companies that might be affected by this law?
Firstly, I think this law marks the beginning of a series of measures, because this law leaves a lot of space for MOFCOM and the Chinese government to issue more implementary and more detailed information for the companies to follow. Mm-hmm. And I think especially multinational corporations should monitor their transactions and alert any transactions that may fall within the scope of these rules, and pay attention to their duty of reporting under the new rules.
All right, we have to leave it there. Many thanks to Fang Yi and David Blair for their insights.